Welcome to the Employment Law Channel here on the Legal Broadcast Network. I'm Scott Drake. A former employee at Solyndra has filed a class action lawsuit against the solar energy company, which unexpectedly closed its doors, claiming that it violated federal laws by not giving its employees proper notice before filing for bankruptcy and laying them off. My guests are Renee Roupinian and Jack Raisner from the law firm of Outten and Golden's Warren Act Practice Group. Renee and Jack, thanks for joining us.
Thank you.
Thank you.
Let's begin by finding out who the plaintiff is and, again, sort of clarify what the claim is.
Sure. Peter Kohlstadt was an engineer at this solar panel manufacturer and had been working there for about 4 or 5 years, sort of from the beginning. And the company had grown and was busy producing solar panels up until the day of its closure. And on that day, Mr. Kohlstadt was informed in the morning that he need not come to work or that the doors were closed, and there would be a meeting that morning that he did attend, and the CEO told the entire workforce that they were being dismissed at that moment, and they all packed their goods and went out the door. The lawsuit is under the Warren Act, as you've mentioned, and it requires that employers in mass layoff or shutdown situations of a certain size carry out their responsibility, which is to give prior written notice to these employees of their termination. And of course, that wasn't done here, and that caused Mr. Kohlstadt to file his lawsuit.
And Solyndra obviously has been in the news a lot lately for this very reason, because of the bankruptcy and the federal loan guarantees associated with it. How many employees are we talking about here?
The company employed roughly 1,100 people, and all but about 100 or so were let go on that fateful morning.
Mm-hmm. Renee, talk about how this procedure works in bankruptcy court and how bankruptcy positions the plaintiffs here.
Sure. So the suit was initiated in the Northern District of California, but then when the company filed for bankruptcy in Delaware in early September, that lawsuit in California was automatically stayed, as were any actions outside of the bankruptcy. So we transferred the case into the bankruptcy court, and the general thinking would be that when a company files for bankruptcy, unsecured creditors such as the employees would be out of luck, but that's not the case. The employees actually have a priority claim, so their claim would come above other general unsecured creditors up to a certain monetary cap, which is about $12,000 per employee. So their 60 days wages and benefits up to that cap would be entitled to priority and be paid in advance of other general unsecured creditors.
So none of these employees were given any kind of severance pay, I'm assuming here, which is the reason for the lawsuit. Talk about, to your knowledge, with the overall bankruptcy here of this company, the kind of situation it is. Do you have any idea of what the debts were as opposed to the assets?
The picture is rather dismal in this case, but that's often true at the outset of a bankruptcy, and that means that there are not enough funds to pay back all of the creditors. And in this case, the number of creditors, or the amount that's due all the creditors, including the government, is rather large. It's more than $500 million, and it doesn't seem as if the company coming into the bankruptcy has that kind of funding or that its liquidation value will amount to that much. But again, this is still an early stage, and a lot happens in bankruptcy.
Right.
It's called reorganization, and the reorganization of the debts are for the purpose of determining if there can be a payout to the creditors. So that process is just beginning.
And in this particular kind of bankruptcy here, there is no chance that Solyndra will come back and opens its doors again. This is pretty much it for the company, right?
You can't say that there is no chance. There is always a chance that the company will find a buyer, and that is one of the express purposes of the debtor in this case. If there is what's called a turnkey buyer that takes the factory and returns it to where it had been, and it's not very likely, but no one can say that it's impossible.
Renee, talk about the plaintiff in this case. Do you get the impression that there was any kind of indication that the company was in this kind of financial trouble, along the way, or was this just a completely sudden type of event?
According to Peter Kohlstadt and other employees that we've spoken with since the closing, this came as a complete surprise, which isn't unusual. The rank and file employees are the last to learn of the company shutting its doors, and often that's purposeful to keep them in the dark because of the company's other agendas, and that's what happened here. The company had apparently been hiring employees relatively close in date to the shutdown, and Peter Kohlstadt himself was very busy doing the work that he was hired to do and trying to cut costs and so forth. So unfortunately for the rank and file employees, this came as a complete shock to them.
For those viewers watching and who are not particularly familiar with the WARN Act, can you talk about what people can take away from this? And I'm talking specifically about the fact that the economy is still bad, and there are lots of companies who could be or have been in this situation.
Sure. The takeaway for people in the workforce is, of course, to keep their ears open for signs of warning or red flags about their future, because you want to have what's called a soft landing. You want to be able to start looking for a job or taking advantage of retraining or doing things to pave the way for possible unemployment, taking care of health insurance, and not making large expensive payments or expenditures at any time when you're not secure in your job. Unfortunately, companies, as Renee said, don't give this kind of a warning for the rank and file. The executives who see it coming give themselves a soft landing by cutting back on their personal expenses or putting away some money or making sure they have continued health insurance. So that is the word of warning for everyone. And then when the day comes, if there is a abrupt layoff, to seek legal counsel. The government is not going to take help with the WARN Act at all in terms of assisting employees with their rights under that law. It's not administered by the government. And for an employee to reach out to a WARN lawyer who can explain how it works and maybe seek to get the due back pay for under the Act and the reimbursement for health expenses and all that's something that employees should be willing and prepared to do if the day, unfortunately, should have to come.
Renee, in closing, just give us a little background on the WARN practice group with Outten and Golden.
Well, we've had the practice since 2007, and our cases vary by industry. But given the current economic times, it shouldn't come as a surprise that most of our cases are litigated in bankruptcy court. It's a national practice, and we have cases all over the country. And although Solyndra may seem like the atypical case given its high profile, unfortunately we've had the experience of litigating WARN cases of this size and larger that have resulted in criminal indictments. We don't know if that's going to happen here, although there is an investigation of some of the executives and so forth in this case, and also have experience in litigating cases where there's government funding.
My guests once again have been Renee Roupinian and Jack Raisner from Outten and Golden's WARN Act Practice Group. Thanks so much to both of you.
Thank you, Scott.
I'm Scott Drake, and you're watching the Employment Law Channel here on the Legal Broadcast Network.